everyone. I'm David Ironson. I currently sit in the Civil Division in Morris County. I'm chair of the Supreme Court Committee on Jury Selection and co-chair of the working group on juror impartiality. And our program today includes two esteemed presenters. Our first presenter is going to be Professor Nina Chernoff. Professor Chernoff is a professor of law at the City University of New York School of Law. And our second presenter will be Dr. Mary Rose, who's a professor of sociology at the University of Texas at Austin. This morning, Professor Chernoff is going to discuss in part how jury panels are created in New Jersey, what are the stages of the jury selection process, how do we go about ensuring that the jury system includes a fair cross-section of the community, as well as what are the best practices that New Jersey has adopted and what strategies can be implemented in the future. Dr. Rose is going to talk to us about her empirical study of jury selection practices and jury participation patterns in New Jersey, and you just might be surprised at some of those findings. Our first presenter, as I indicated, is Professor Chernoff. Professor Chernoff received her BA in sociology from Bryn Mawr College. She received an MS with distinction in justice, law, and society from the School of Public Affairs at American University. Professor Chernoff graduated from the Georgetown University Law Center, magna cum laude. She also clerked in the United States Court of Appeals for the Third Circuit for Judge Thomas Ambro. And prior to joining CUNY's faculty at the School of Law, Professor Chernoff was an acting assistant professor of lawyering at New York University Law School. And her research focus is on the jury, primarily the right to for a jury to be selected from a fair cross-section of our community. Dr. Rose received her AB in psychology from Stanford University, and she received her PhD in social psychology from Duke University. Dr. Rose is currently, as I mentioned, a professor of sociology at the University of Texas at Austin, and Dr. Rose's research examines lay participation in the legal system and perceptions of justice. And Dr. Rose's research has been cited by numerous court cases, including 3 United States Supreme Court cases. And we're happy to have both of them here with us. And we'll start with Professor Chernoff.
Thank you so much. I've been trusted to run my own PowerPoint, so we'll see if that was a good decision or not. All right. So this symposium is largely focused on peremptory strikes, implicit bias, and explicit racism. And I'm not going to talk about any of those things. So why? Because I want us to focus, I want to highlight the stages of jury selection that may be more important than peremptory strikes when it comes to assembling a group of people in the courtroom who really reflect our community. I'm talking about the invisible stages of jury selection that occur before the voir dire process even begins, that occur before the lawyers get involved at all. And these are invisible stages in the sense that they don't take place in front of the judge or the lawyers or the parties, and instead are the product of decisions that are made by the administrative office of the court, by jury office personnel, by the state Supreme Court, and by the legislature. There are 5 of these invisible stages of jury selection. The first, stage 1, is the selection of source lists. So identifying the lists to be used as a source for juror names and merging them into a master jury list. At stage 2, the jurisdiction takes steps or doesn't take steps to update the addresses on that jury list, which is necessary to make sure that the summons actually reach the people that they're intended to reach. At stage 3, the jury office sends the summons out, and at stage 4, the jury office deals with the responses to those summons, which include, as we've heard, requests to be excused from jury service on the grounds of financial hardship. It includes some people who fail to respond completely, and it always includes some number of summons that are returned as undeliverable by the Postal Service because the person no longer lives at that address. And at stage 5, the jury office removes from the master jury list those people who don't meet the eligibility criteria set by statute. And then we have a group of people who are at the courthouse on a given day, ready to start the voir dire process, which of course includes for cause strikes and peremptory strikes. The key is that in many jurisdictions, this group of people who are ready to go through voir dire do not represent their communities. And that is likely true in New Jersey as well. It's true nationally, and it is likely true here. Indeed, Dr. Rose's study of the New Jersey jury system found that the data support the conclusion that people who appear for jury service do not fully reflect their communities, do not fully represent their communities. And again, that's before the voir dire process starts. Specifically, Dr. Rose's study found that the processes that determine who appears at the courthouse constitute a systemic source of minority group attrition because concerning levels of underrepresentation appeared in nearly all the areas studied, and in particular, substantial underrepresentation of African Americans is commonplace. So that's why I don't want to talk about peremptory strikes or voir dire, because I want to draw our attention to how these 5 invisible stages of jury selection before peremptory strikes might be inhibiting New Jersey's ability to assemble diverse jury pools and what we can do to fix it. I also said, though, that I wasn't going to be talking about implicit bias or explicit racism, and that's only because they are legally irrelevant to the legal constitutional question about whether the fair cross-section right is satisfied. And that's because of the distinction between the right to a jury selected from a fair cross-section under the 6th Amendment and the right to equal protection under the 14th Amendment. So the right to equal protection obviously prohibits discrimination, and it applies to every stage of the jury selection process, which is, of course, why a discriminatory peremptory strike violates the Equal Protection Clause. Essentially, equal protection requires us to refrain from doing something, discriminating. But in contrast, the fair cross-section right imposes an affirmative duty on the state to produce something, a representative jury pool, a pool that includes a fair cross-section of the community. This right only applies to those invisible stages of jury selection that occur before voir dire. And the key is that it's irrelevant to the fair cross-section right whether the reason that the jury pool is not representative is intentional or completely accidental. There's no intent requirement to the enforcement of the fair cross-section right and no requirement that there be any discrimination involved. And as we'll see, the disparity at these invisible stages of jury selection is often caused by policy decisions that are race neutral, that are made with no discriminatory intent, and yet they end up interacting with systemic inequalities in our country and having and have the inadvertent result of producing a jury pool that doesn't reflect the community. So again, the question is, how might these 5 invisible stages of jury selection be impairing New Jersey's ability to fulfill its affirmative duty to produce a pool of people who represent a fair cross-section of the community who can then go through the voir dire process? And as a part of answering that, I hope to highlight best practices that New Jersey has already adopted along with areas for improvement. So let's start with stage 1. This is where the jurisdiction identifies lists of source lists to use for juror names. And this is a critical stage because the jury system can certainly never get more diverse than the source lists used to create it. And it's important to have a selection of source lists that's robust enough to handle the reality that people are going to be removed at subsequent stages of jury selection. So robust enough to go through that process and still produce a representative pool of people at the courthouse. Now, New Jersey already employs the best practice of using multiple source lists, which is excellent. Specifically, as you've heard, New Jersey combines the list of registered voters, the list of licensed drivers, and the Division of Taxation contributes a list of filers of state income tax and filers of homestead rebate or credit application forms. But the statute expressly provides for the addition of other source lists. Both the assignment judge and the Supreme Court appear to have the power to add lists, as Judge Thornton mentioned at the last panel. And examples of lists used by other states include lists of people who receive unemployment benefits, who receive public benefits, who hold utility accounts. And I understand that legislation has been proposed in New Jersey to add the list of recipients of cash assistance or food stamps. The key is not so much how many lists do we have and whether it's more or less than other states, but how well do those lists capture the full community? And if the full community isn't reflected in the existing source list, the court should use the existing statutory authority to add more. So I add that as one step that New Jersey could take is to assess how well the current source lists really capture the full community with particular attention to communities of color, and if it would be useful if we could get new names and new people by adding source lists to do so. At stage 2, the jurisdiction has to decide how often to update the addresses on the list. And some of you might be thinking that this sounds like a boring administrative decision, and what difference does it make to diversity? But the starting point is that jury participation across the country is significantly reduced by summons that are sent out by the jury office and then returned by the Postal Service as undeliverable because the person's no longer at that address. And the rates of the undeliverable summons, this is the key part, the rate of undeliverable summons are higher in communities of color. And this is largely the product of the correlation between race and income that is itself the product of systemic racism. So if you look at the home ownership rates of by race and ethnicity across the country, you can see that there are vastly different home ownership rates for white and Black communities. And that's important for updating addresses because consistently, people who rent their homes move far more frequently than people who own their homes. And therefore, we see different rates of residential mobility by race and ethnicity across the country. And it makes a difference because let's say a jurisdiction updates their address list every 2 years. There's potentially going to miss all of the people who move within that 2-year period. But if they update their addresses every 6 months, they're only going to miss the people who move during that shorter period of time. And it's important because those missing jurors are more likely to be people of color. And if we look at New Jersey, we can see that as is true nationally, the home ownership rate for African Americans is much lower than the home ownership rate for white households. So in New Jersey, almost 77% of non-Hispanic white households own their home, compared to 41% of Black households in the state. And in some areas, the household ownership rate is much lower, like in Newark, it's only 22%. So you're going to have more mobility in those areas. And it follows that in New Jersey, as is true everywhere, African Americans were more likely to be movers than other groups. So because of the importance of having accurate addresses, the American Bar Association and its principles for juries and jury trials, which has been endorsed by the Conference of Chief Judges of all the states, recommends that jurisdictions update their lists at least annually. And that's what New Jersey does. Annual updates, so that's great. But one suggestion for improvement is to update more frequently because the National Center for State Courts, really the leading experts on jury management, suggests that courts that are located in areas where they have a higher residential mobility rate should consider updating their addresses, their lists more frequently, like semi-annually or quarterly if feasible. So New Mexico, for example, updates their lists every 6 months, and the Eastern District of Pennsylvania, includes Philly, does it every 6 months as well. So that's one suggestion for improvement, is to increase the frequency with which addresses are updated. There are 2 other approaches that courts can take at this stage of jury selection to improve addresses, and New Jersey already does both of them. So I'll move through this, just note them quickly. So one approach is to submit addresses through something called the National Change of Address Database, which is a fee-based service that updates addresses. Approximately 10 to 15% of addresses can get corrected with this database, and New Jersey already does that. It's excellent. And then a second key to getting good addresses is another kind of like boring detail that makes a big difference, is when you merge multiple lists, you have to tell the computer program which list from which to select the address. And in New Jersey, driver's licenses are updated every 4 years, but you pay your taxes every year. And so the program appropriately grabs the address from the most frequently updated list. And again, that's something that New Jersey already does. So that's good and important. Now, moving on to stage 3, this is where the jurisdiction sends out the jury summons. Again, the ability of those summons to reach the people for whom they're intended depends on the accuracy of the addresses. And another factor that can affect how successful the summons are in reaching people is whether the jurisdiction uses a one-step mailing, which combines the eligibility questionnaire with the summons, or a 2-step process, which sends out the eligibility questionnaire and then sends the summons only to those people who are eligible. The one-step process is better. It has a lower undeliverable rate, and that is the process that New Jersey uses. So that's another best practice that's already been adopted here. Now at stage 4, the jurisdiction deals with the responses to those summons. And this is another place where we see facially neutral policies interacting with systemic inequality in ways that diminish jury diversity. So this is an area that's ripe for reform. So the responses that the jury office can get when the summons get returned, one, as we said, is undeliverable, returned by the post office, bad address. Some people don't respond to the summons at all, and some people respond by saying that they can't afford to serve as jurors. So when it comes to undeliverable summons, one approach to maintaining diversity in the face of these undeliverable summons is to send a replacement summons to a new person in the same zip code. Now, this has the power to increase diversity in jurisdictions where people live in racially or ethnically concentrated zip codes, which is true in a lot of the United States. So it doesn't guarantee diversity, but it gives us more of a fighting chance. And there's obviously other people here with more expertise on the extent of residential segregation in New Jersey. But if we look at a map of just where we're sitting now, where I think we're sitting now, you can see that we're in an area of high racial segregation, and there are other areas with less racial segregation. The key is that sending out a replacement summons to the same zip code will be a more effective tool for maintaining diversity when the zip codes are more racially or ethnically concentrated. And at least 17 federal courts do this. They send out a replacement summons when a summons is returned as undeliverable. So for example, here's language from the jury plan of the Eastern District of Pennsylvania, again, Philly. So when either a summons is returned as undeliverable by the post office, or when the clerk's office doesn't get a response at all, the clerk is directed to send a replacement summons to the same zip code. And Honorable Juan Sanchez, the chief judge of that court, explained that the express purpose of sending out the replacement summons to the same zip code is to maintain both geographic proportionality and representation. So one best practice that New Jersey could adopt is sending a replacement summons to the zip code when a summons is returned as undeliverable. Now, sometimes a summons isn't returned at all. And the number of non-responses also has the potential to affect the diversity of the jury pool because non-response rates seem to be higher for communities of color. But this is not the case once you control for income. When we control for income, there is no difference in response rates along race or ethnic lines. And I want to pause and highlight this point because we might be thinking about this might feel counterintuitive to some of us. If we're thinking about aggregate data that shows that in the aggregate, Black people report higher levels of skepticism about the fairness of the criminal justice system, we might be tempted to extrapolate from that the idea that people in communities of color might be less likely to want to come in and serve as jurors. But the data do not support that conclusion. When we control for income, we all resign ourselves to jury service with the same groan. I would actually love to be on a jury, but I think that my desire to be on it is like a force field that keeps the summons from ever reaching me. So in any event, it's really more accurate to say that non-response rates are higher for poorer communities. And because of structural inequality and systemic racism, a high non-response rate means a less diverse pool. So the non-response rate might feel like something over which the court has no control. But actually, the National Center for State Courts has identified non-response and failure to appear rates as some of the components of jury yield that have the most potential for effective control by the state. Specifically, there are 3 things that courts can do when faced with a non-response that have the power to maintain diversity. One best practice that courts can use to reduce the non-response rate is to send a follow-up notice to the person who didn't respond. This notice can remind them of the importance of serving as a juror. It can help provide more detail about how to request a hardship exemption. It can emphasize the penalties or sanctions for not serving. Now, New Jersey already sends a paper copy of the summons when someone fails to respond to the initial mailing. So the suggestion I have for reform is to consider, perhaps in the context of a pilot program, adding language to the reminder to see what is most effective. Is it the emphasis of sanctions? Is it more information about hardship exemptions? Because the data is very strong about the value of a follow-up mailing in decreasing the non-response rate. A second step that courts can take to that has the potential to reduce the non-response rate is to make adjustments to the mailing that makes it easier to understand how to request an excusal, how to understand whether you're qualified, or how to defer. And I don't have data on what language or what format of the summons is most effective, but there is evidence that non-responders often don't know how to go about rescheduling jury service, or are less likely than people who do respond to believe that they can defer service. And the report prepared for this symposium similarly reported that when talking to non-responsive jurors in New Jersey, some reported that they didn't respond because they believed they were not eligible. So one suggestion for improvement is to modify or clarify the summons form to address some of those concerns and make it easier to understand so that people will be more inclined to write back when they get it. And a final approach that doesn't affect the non-response rate, but affects the impact that it has on diversity is, as with undeliverables, to send a replacement summons to a new person in the same zip code. And a number of courts do that as well, federal and state. So that's another recommendation that New Jersey could adopt, to send a replacement summons when there's no response to the reminder notice. Now, another response that courts face when summons are sent out is the response that jury service imposes too great of a financial hardship. And the issue of juror pay was one of the points raised by the Chief Justice earlier this morning. In New Jersey, potential jurors can request to be excused if serving will impose a severe financial hardship that will compromise their ability to support themselves or their dependents. And as you can imagine, the economic burden of jury service has an impact on diversity because of the relationship of race and income in our country. So in a state like New Jersey, where the median net worth for white families is $352,000, and the median net worth for Hispanic or Latinx families is $7,300, and the median net worth for Black families is $6,100, you're going to see a disparate impact when you ask people to take off work in exchange for a few dollars. Particularly given that employers of higher wage workers are more likely to pay for their employees' time on jury service than are employers of lower wage workers. So what are the best practices when it comes to ameliorating the disparate economic impact of jury service? The answer is a combination of increased juror pay with a shorter term of jury service, specifically a term of jury service known as one day or one trial. So the National Center for State Courts, they conducted a national survey looking at this, and they compared courts that had juror fees over the national average at the time with those that were below the national average, and compared courts that used the shorter one day, one trial length of service with those who did not have a limit or had a longer term of service than one day or one trial. And they looked at what this did to the excuse rates by jurors. And what they found was that courts with longer terms of service and lower than average juror fees had a high excusal rate of 9.3%, compared to the courts that had a shorter term of service and a higher rate of pay had a lower excusal rate of only 4%. So two other recommendations for New Jersey are to shift all of the New Jersey counties to a one day, one trial system. I understand about a third of the counties already use that, and to increase juror pay. And in terms of juror pay, the key is not to ask, what do we pay compared to other states? Because you obviously can't convince someone that they can afford to take off work by telling them, well, you'd be paid less in Nebraska. The key is to compare and evaluate juror pay in relationship to minimum wage in the state, or the amount of money that the average juror loses when they serve. Now, finally, at stage 5, the jury office removes from the master list anyone who doesn't meet the eligibility requirements set by statute. And another point raised by the Chief Justice this morning was that in New Jersey, that involves removing from the jury list anyone who has ever been convicted of a felony. And this lifetime ban has an impact on the diversity of the jury pool, because the felony conviction rate in New Jersey is 0.33%, but the felony conviction rate for Black people in New Jersey is 4 times higher at 1.43%. So it's a jury eligibility requirement that has a disparate racial impact. And the purported bases, my PowerPoint is moving on its own. It's trying to keep me on time. The purported bases for the felon exclusion have largely not been tested, and they are being tested now, and the data that's coming out is undermining those rationales. So one argument or rationale for excluding people with felony convictions is that they're likely to be more biased against the prosecution. They won't be fair jurors. And there was a recent study that showed that, first of all, not all people with felony convictions, it's not a monolith. In the study, a third of the sample had a neutral or pro-prosecution bias. But even when we look at the majority of people with a felony conviction in these studies who did have a pretrial pro-defense bias, it was the same level of pretrial pro-defense bias as reported by law students. And it matched the pretrial pro-prosecution bias of law enforcement. But we don't have a categorical ban on law students or members of law enforcement serving as jurors. And what's more, in the voir dire process, we have an opportunity for people who can't be fair to be excluded. A second rationale for the felon exclusion rule is the idea that other people without felony convictions won't want to serve as jurors or won't have as good of an experience. And a recent study of mixed juries, so people without convictions and with, found that it either had no effect on or actually increased juror satisfaction among the other jurors. And specifically, those other jurors were more likely to feel that the deliberations were helpful and that their own opinions were highly valued. And finally, another rationale is this concern that if people know that people with felony convictions are on juries, it will undermine the integrity of the process. And in fact, some of the studies show that it makes it more likely that the jury will trust the verdict, which is consistent with all the literature that shows that people are more likely to trust the verdict of diverse juries. So the best practice here, as identified by the American Bar Association, is to eliminate the ban on jury service for people with felony convictions, unless they're actually on court supervision. So I'll close with this summary slide that lists the best practices that New Jersey has already adopted and some suggestions for improvement that could help the state maintain and build a more diverse jury system. Thank you so much. It has really been an honor to be invited to participate in this effort.
Thank you so much. All right, so we'll go to Dr. Rose now. Dr. Rose, good morning.
Good morning. I hope you can hear me.
In Texas.
Yes, it is. Thank you. I'm going to jump right in and share my screen. So I'll begin also with tremendous thanks for inviting me to share results that I have from New Jersey's self-study of its jury selection processes. This is an area of my research and so close to my heart, and I'm delighted to be on a panel with Professor Chernoff, whose work I admire so very much. You may have, some of you may be aware of what I was asked to focus on in this research. In particular, it was a look at who's showing up to the courthouse and how racially and ethnically diverse are the jury pools in those counties that participated in this study. Professor Chernoff has already recognized that my finding in there is that there is more work to do on that score, that pretty much across counties, the jury pools are not fully representing the areas from which they're drawing. But I'm going to focus today on other areas that I was asked to focus on, which is once people are at the courthouse, what are we seeing in terms of patterns of attrition? How are people exiting jury service? Who is appearing on juries? And basically what patterns do we see? And of course, in this era, and because New Jersey is wanting to think about this issue, then the question is whether any of these patterns of attrition correlate with somebody's race, ethnicity, or gender. So I want to say quickly that these questions and the look at who serves on juries is an important one to me, and one that I've written on, because the research literature makes a pretty clear case that serving on juries is beneficial to the people who serve. So we find a number of correlates of jury service. One is simply that people who serve on juries have more positive views of courts. And you may quickly want to say that maybe we're just selecting people who are particularly court friendly, but there are actually studies that have shown over time, if you're able to get people's views before they serve and then test them afterwards, there is an improvement in how they see judges and how they see how courts work. And so there is an enhancement. John Gastill has developed some fascinating data that shows that people who were able to participate on criminal juries and deliberate, it seemed to teach them about habits of democracy and deliberation and the high stakes kinds of decision making, and that people who had that experience were actually more likely to vote in a subsequent election following their service. And then in particular, jury service seems to have some beneficial effects for minority group members who are asked their opinions about juries, and they express more support for juries as an institution when they have served. I want to be very clear that I do not believe that everybody should be on a jury. Some people shouldn't be on the jury, and some people are not able to be on the jury. I simply note this research to say that scholars come at this with an aim of trying to maximize the opportunities for citizens to serve, and obviously for a fair cross-section of people to serve, because it has these benefits. So we don't want to do anything that limits that unnecessarily for people who can and should. So how I got involved in this is I was asked to analyze data that the administrative office collected. They designed and implemented a study. It was a multi-week study done in multiple counties across New Jersey. This was in the pre-COVID period, so courts weren't having to deal with the mess that we are all having to deal with these days. And these counties represented a good cross-section of the state. And what they did is, for people who reported for service in any way, they were given just a simple questionnaire to ask them to self-report their race, whether they self-identified as Latino or Latina, and their gender. And what they did is assign a barcode that linked this questionnaire with the outcome that the jury management software had for that person. This is not data that New Jersey normally collects, and so they had to engage in this study to get people to report how they self-identified, and that's important. They're self-identifying. Nobody in the study is sitting there counting how many people they think are of a particular group. It is all based on self-report. And then they were able, using that barcode data, to provide the data to me in a way that's de-identified and protects confidentiality. And then I could analyze for the questions that I've already outlined, which I did during the last year. So I'm going to jump right into the findings in the name of time. One of the most significant findings that I saw in what I analyzed is how very common the not used category is. So lots of people come to the courthouse and they sit all day in the jury waiting room. That is not the group I'm talking about. About 41% of people in the study only made it as far as the jury waiting room. I'm talking about once you now form a panel or a veneer, those I'm going to use interchangeably in this talk, and are sent to a courtroom for voir dire. That I am talking about the people who are never questioned or considered. They're not struck either by lawyers or the judge, and they're not selected. They are just not used. And this is what I believe is in conjunction with very large panel sizes that New Jersey forms for the voir dire process. So just to give you a sense, the not used category was the most common outcome for those who went to courtrooms to participate potentially on a civil case. And it was the second most common outcome in criminal cases. It was behind challenges for cause. So this is a very common way that people exit jury service. And again, I do see this as necessarily linked with the fact that New Jersey forms large panels. So the average size of a jury panel for a criminal case is about 144 people. The median, that means the 50% mark. If you lined up the distribution of all panel sizes, it would be the one that's in the middle. So half the panels that are formed are 122 people or more, half or less in criminal cases. For civil cases, the average is 53 and the median is 44. Now, I've referred to these as large. I recognize that every community needs to decide on its own what is appropriate for its community, but I do contrast it with the National Center for State Courts issues recommendations for best practices, as Professor Chernoff already referenced, and they have a recommendation, New Jersey specific, given its jury size, its peremptories, of 70 for a criminal case and 37 for a civil case. So you can see that in criminal cases, New Jersey has forming panels that are twice as large as that recommended, and substantially higher on the civil side as well. Now, again, it is up to New Jersey to decide, but you can see, looking across counties, that nearly all of the counties are coming in well ahead of what is considered best practices from the National Center, and it is higher than what I see in other jurisdictions that I study. You see here the average size in the trials that were studied during this period for criminal cases and for civil cases. Most of the areas in criminal cases are above 100, and civil cases are typically above the recommendation of 37. And obviously happy to go through more detail in the Q&A. The second finding is, as I've said, New Jersey has large panel sizes, and I think that reflects the fact that there are a large number of peremptory challenges in this state. That's part of the planning that attorneys go through that court administrators go through in trying to plan for how many people to send to the courtroom, and planning for 20 peremptories is part of what they're doing. And what we see naturally in a state with so many peremptory challenges is a request and an interest in whether this is the way that minority people may be excused and experiencing attrition from jury service. Is it the case that with so many peremptory challenges, you are affecting the diversity of the pool and of juries in this way? And my findings, as was mentioned, are a little surprising in this score, in that I do feel that peremptory challenges, and the data suggests, they play a role in dismissing minority group members, but it is an attenuated one. Basically, the effects for race that I saw for race and ethnicity in the data tended to be case specific, trial specific, and not system wide in the same way that other findings were. And there was I was trying to think of the best way to convey this. And so I took the findings that I looked at where there was at least one African-American in a jury pool. And there were 85 trials of all the ones that I studied, in which case there was an African-American. And I then looked at in what instance did peremptories remove at least 25% of that group for that trial. So at least 25% of African Americans were removed. And I called this, as I did throughout the report at different stages, a concerning level of attrition. And that outcome occurred in 13 of the 85 cases. For Latinos, it was, there were 18 instances out of 91 trials in which at least 25% of those who were present were eliminated through peremptories. And for Asian Americans, it reflected what you saw for African Americans, is about 13 to 85 of 85 trials. So what we are seeing is, it's certainly the case that peremptories exercised by the various sites can eliminate substantial numbers of people, particularly in locations where there are just not very many in the jury pool to begin with. But in most cases, you're not seeing that pattern. So that is a finding that was surprising for me. So I don't want to dismiss the importance of race by any means, but simply to say that it is an attenuated one. The fact that I sort of didn't see what I expected to see, I believe reflects a broader finding in this study, which was that attorneys rarely use the full complement of peremptory challenges that are allotted to them through statute. So I'm dividing here between criminal trials and civil trials, because they obviously have different numbers allotted to them. And this table here simply gives you the average number of peremptories used by each side in the criminal cases, so state versus defense, and then in civil cases, plaintiff versus defense. And what you can see is that on average across all the trials, criminal trials that I studied, the state used about 4 challenges. That's when whether you look at the average or the median, that halfway point, and the defense to use between 5 and 6, depending whether you're looking at the average or the median. And this is, again, in light of the fact that the defense is allotted 20 and the state is allotted, I believe it's 12, and at the 75th percentile, so this is moving on to those who are in the top 25% of those using peremptory challenges, you're still not seeing the full use of peremptory challenges. It's 6 for the state and 9 for the defense. And then in the 90th percentile, at that demarcation in the distribution, it is 7 and 13. And you can see the pattern in civil cases that it is only the defense in civil trials that uses the full complement of peremptory challenges at the 90th percentile. So just the pattern stands out to me that attorneys currently are not using the full complement of peremptory challenges that are allotted to them in both kinds of trials. Now, I am on record and I have written on the peremptory challenge and the cause challenge, and I am somebody who believes that peremptory challenges play a role in jury selection, in part because I certainly have studied and seen and hear about instances in which peremptories compensate for cause challenges that are not granted, right? So a judge may be quite conservative on saying yes to a challenge for cause, may require that the juror say the magic words of I cannot be fair, I will not be fair, before they will grant a challenge for cause. And so I'm interested for these data in whether the use of peremptory challenges seems to track the use of cause challenges. And this idea that peremptory challenges are compensating for judicial behavior and judicial conservatism on challenges is something I was very interested in. And so what we, in social science, we call that relationship, that particular pattern, a negative correlation. What we say is, wow, it should be the case that as judges are being more strict about giving challenges for cause, you should see peremptory use rise up and go up because they're having to offset these judges who are being stingy. And that leads to a finding that certainly surprised me, which is that peremptory challenges and the rate of judges using cause challenges in criminal cases is actually positively correlated. So in just normal terms, what that means is what you find in criminal cases is that as cause challenges become more commonplace in jury selection, there are also more peremptory challenges. So if you're a numbers person and interested in the actual relationship, it's about 0.4 as a correlation coefficient for defense peremptories and for the state. And it suggests that judges and attorneys are looking at a jury pool and being responsive to some of the same patterns they're seeing. They're both increasing their strikes that they're allotted in response to the veneer before them. You don't see this pattern in civil cases. There is a weak relationship, positive relationship between the way that defense attorneys are exercising challenges and no relationship between plaintiff exercises and judicial, the rates of judicial challenges for cause. And some of this is explained by the fact that the distribution of cause challenges and peremptory challenges is very different across these types of cases. It would be harder in civil cases to find that relationship because the rate of judges using challenges for cause is lower in civil cases and much higher in criminal cases. So peremptories there are more peremptories and there are more judges are being more active on granting challenges for cause in criminal cases. This obviously leads me to questions about cause challenges and what other possible correlates might explain judges using challenges for cause and what effects those might have. The other positive correlation that I saw is that cause challenges tend to be more frequent and granted more often when the veneer size is larger. So larger panels mean that that proportion of people excused through challenges for cause is higher. And I didn't find, again, any association that was system-wide between juror race and ethnicity in judges' use of challenges for cause. There were case-specific instances where it appeared that challenges for cause explained absences of minority group members to some extent in particular trials in particular areas, but this was not a systematic pattern that I saw across. So I want to summarize and leave some time here for the Q&A. Basically, what I'm here to say is that the panels and veneers in New Jersey are very large, and that attorneys are rarely using the allotment of peremptory challenges. So to the extent that the panels are large as a way to plan for that usage, we're just not seeing that attorneys are coming along and using that allotment in most trials. And that it appears to me that the system typically works in tandem with one another. Challenges for cause go up as peremptory challenges go up, and vice versa. And that these panels, again, are likely larger when they're planning for peremptory use. Now, as I said, the race effects that I saw were pretty, specific to particular cases and trials. But I am emphasizing here the fact of panel sizes, and that's because I do want to emphasize that scholars in this area agree that large panel sizes simply are not cost-free. It may seem like what's the big deal of having large panel sizes, but there are obviously monetary costs associated with staff who must populate those panels and interact with more people, issue and keep track of more people. And for the citizens, there are certainly economic costs to going to court when they are not going to be used. They have to get themselves to court through transportation. They have to arrange for childcare in some instances, and they're obviously often taking time away from work to do so. So those are real costs. But the National Center for State Courts in this jury manager's toolbox and best practices talks about the fact that even separate from monetary costs are lost trust and confidence in courts by people who simply go to court but do not have this meaningful experience that I referenced above, but they see other people having it, people who are impaneled, as well as including potentially people who are challenged and excused. It's not easy to quantify what the cost of this is, but definitely an urging not to ignore it. And with that, I would like to stop sharing.
All right, thank you, Dr. Rose. So what we'd like to do now, if there are any questions from the audience, if you could just line up over here to my right, but let me start off first by asking Dr. Rose a question. Your analysis did not show that peremptory challenges are the major point at which people of color are eliminated from veneers. Doesn't that show that a reduction in peremptory challenges is misplaced?
I feel that there's really two issues here. One, I didn't find system-wide race effects in peremptories as they are currently exercised. So I hope you got a sense that attorneys appear quite restrained in how they're exercising challenges, given the allotment that they have. I have no confidence that if suddenly those numbers went up, that that the restraint would appear that the race effects would continue to be null. And whenever you see instances where attorneys do have a lot of peremptories and use those peremptories aggressively, it typically is associated with racialized patterns. So I do feel like the race effects that I am talking about need to be you need to keep in mind the way that peremptories are used. Finally, or in addition, I think that if as we suggest, that the goal is to get a more diverse jury pool, to the extent that peremptories can pick off even a few people from that in ways that are concerning or raise questions about fairness, it is, in my mind, not unreasonable to ask questions about whether peremptories can do harm. And certainly to the extent that panel sizes are large, I have questions about whether I happen to believe that it's reasonable to ask whether peremptories there could be fewer.
All right. Any questions? People from the audience, please come on up. Don't be shy. But let me pose a question to Professor Chernoff. You highlight institutional barriers to service, including based on economic burdens. Is there data to show that paying a certain amount, say $25 or $50 per day, actually increases diversity in jury veneers?
Yes, I mean, data is what we all want to be the basis of our decisions, and it's what we don't have. As just a broad brush preliminary matter, most courts fail to collect the race and ethnicity data that they need to assess whether they are complying with the Constitution, whether they're complying with the statute, and where any diversity losses are happening such that reforms could be targeted, which is why it's so important and exciting that New Jersey is moving to collect this data, because that will empower us to answer questions like that. What we have instead is a combination of data that shows that an increase in jury pay increases the overall jury yield, like the number of people you get in the courthouse for sum and sent, and separate data that shows that an increase in jury yield brings in a more diverse group of people. And so putting those together is where we get the diversity increase from a pay increase. A couple of examples: El Paso, Texas increased juror pay from $6 to $40 a day, and participation in jury service jumped from 22% to 46% within 1 year, and then climbed to 60%. And New York also changed its participation rate by increasing juror pay and requiring larger businesses to pay employees for jury service. They went from $7.50 a day to $40 a day. And as a result of these and other changes, their participation rate jumped from 12% to 39%. So you're seeing big impacts. There's a new initiative in San Francisco, many of us have heard about, designed to increase diversity. Certain low-income jurors are being paid $100 a day. And so there will be data from that as well. And one question I'd love to have answered is, we know that the same people in New Jersey are being summoned for federal jury service and being paid $50 a day. So I'd just be curious, what is the excusal rate for the same population in federal court as compared to the excusal rate we have here? Because that would give us some information about the potential impact of the change.
All right, thank you. Dr. Rose, some attorneys contend that judges in New Jersey are reluctant to excuse jurors for cause. Does your data support that, number one? And what would you expect to see in terms of peremptory use if judges were not willing to excuse for cause?
So on the first point, I do want to emphasize I had, data on outcomes and on types of people. So I didn't observe a particular jury selection or the questions that were asked or any of that. With that said, the rates of challenges for cause that I saw among New Jersey judges was very high compared to places that I have looked at this question elsewhere. The National Center for State Courts, in that panel planning that they discussed, expects about 10 challenges for hardship and cause in a given trial. And I did not see anything like that here in New Jersey, much higher. And I understand that attorneys are saying some of this reflects hardship and other issues, but the data in no way support that judges are being reluctant. And again, that correlates positively with peremptory challenge use. So I'm not saying that offset or compensatory issue, as I mentioned. The second issue is, what if they started to kind of ratchet down and be more conservative about granting challenges for cause? And I make a point in my report in a couple places to say, please don't do that, because my expectation is that that will increase peremptory challenges. That I expect that because you do see this negative relationship that I have talked about, that desire to offset judicial behavior in other places. Whenever you see people advocating that peremptories be entirely eliminated, in most instances, the author of that proposal will say judges need to be more liberal on challenges for cause, which to me says that there's a concern that they're currently not being liberal enough, and that attorneys, they're letting attorneys handle this through peremptory challenges. And then finally, if judges are very conservative on challenges for cause, it tends to create the opportunity to appeal that decision, at least on the part of the defense in criminal cases. And in order to do that, you have to have exhausted all your peremptory challenges, which means if an attorney sees that they're going, they have a judge who's being very reluctant to grant challenges for cause, and they want to preserve that as an issue for appeal, they're going to start aggressively using all their challenges, which means they're just going to be picking off people to be able to say that they did. So I do feel that that this relationship between cause challenges and peremptories needs to be taken seriously, and that it's important for judges to recognize that peremptories may be a safety valve for attorneys, but should be a minimal one.
All right, thank you. One more for Professor Chernoff. You suggested following up with multiple mailings when a juror does not respond to the initial summons. Do you recommend any sort of consequence for a juror's non-appearance? And should the court make summoned jurors come in and explain to the judge why they did not appear?
Okay, short answer, no. Longer answer, we know for sure that mailing some kind of follow-up changes the response rate. It brings it down. So the National Center for State Courts has found in multiple studies that sending a follow-up notice can bring the response rate down 30 to 46%. It has a huge impact on the non-response rate. And on the one hand, there's a little evidence that emphasizing the sanctions for not serving can change people's behavior. So there was a sanctions notification program in Los Angeles that resulted in an additional 10% gain in jurors when they sent out a notice that reminded them about the sanctions. And the California courts actually have a failure to appear toolkit that could be adopted by any state for those details. But I overall don't recommend an emphasis on sanctions in the reminder notice for two reasons. First, there's no evidence that the people who don't respond are lacking a sense of seriousness about jury duty or have kind of a diminished sense of civic duty. Instead, all of the evidence suggests that people who don't respond either don't understand the instructions or can't afford to serve. So sanctions is kind of a solution to a problem for which there's no data support. And second, if we impose sanctions on non-responders, again, because of the correlations between race and income, we're going to be imposing more sanctions on people of color. So we're going to bring in more people of color into the court system for corrective or punitive action as a part of a larger effort to address the disproportionate punishment of people of color. So to my mind, it doesn't really meet any of the needs that we're trying to address here, particularly in the absence of data that shows that sanctions are the key to reducing the non-response rate. So I don't think that's the best approach, but certainly some kind of reminder, ideally emphasizing how to defer, how to get excused, and how to understand the eligibility requirements.
All right, thank you. I do have one last question, but let's go to our bar president first.
Thank you, Judge. Dominic Armino. I'll get to my question. Professor Chernow, it's interesting. When we were permitted to speak to juries, we're no longer permitted to do that after trials. I did notice that we would speak to juries almost to a person. They would say that they enjoyed participating in the process. So I found that your comments on that very interesting. I had a question for Dr. Rose. Dr. Rose, thank you for your report. And one of the things that we noticed in reviewing it was the high percentage that you attributed to for-cause challenges. And one of the things we were trying to understand in that is whether or not there was an analysis done of attorney for-cause challenges, or if you were including within that percentage anyone who was excused before a peremptory was used. Because I will tell you that most of the attorneys in the state, almost to a person, have reviewed that percentage and think it is very, very high in terms of attorneys who actually make a motion to a judge to have someone removed for cause after voir dire has commenced. So we were curious to know what was included in the makeup of the for-cause percentage. Thank you.
Thank you for your question. And I referenced this, but just to be very clear, I only had a result. And so it would say, you know, in a column in the jury management software, what was the result for this person? And it would just say challenge for cause. It didn't specify if that emerged from a judge talking to a juror and saying, oh, it sounds like you really can't serve right now, or it sounds like you can't be fair, and on his or her own making that challenge for cause, versus an attorney trying to persuade the judge that this is somebody who should be dismissed for a challenge for cause, and the judge then granting it. So the jury management software didn't make that distinction for me, so I don't have a way of distinguishing it.
Judge, can I ask one more question?
Sure, of course.
Dr. Rose, you had great detail on the number of folks that are brought to the courthouse as part of the veneer. But each of the counties that were analyzed seem to have really different numbers. Was there any analysis done of why the counties were bringing in different numbers? Was there any formula? Was there any assessment of, the time of the year, the nature of the cases, anything where you could attribute why the numbers were different?
Oh, thank you. Thankfully, the administrative office helped me with the time of year because everybody was doing trials at the same period, so roughly September, October. So that was held constant in this study, or roughly constant. A question to ask is if people who are planning the sites for panels are anticipating a lot of requests for hardship, a lot of requests for, this trial is long and I am not going to be able to do it. If that is playing into it. And so my prediction would be that potentially counties that have maybe more income diversity, that they have people at the lower ends as well as the upper ends, and are contending with that, are planning for more hardship excuses as they make estimates of the right panel size. But I would have to go back and look at something like, median income in that county to look for that kind of correlation. It's something very doable.
Thank you. Thank you.
Thank you. We're running out of time, but one last question that I think we'll squeeze you in as well. But let me just get this question off quick. To both panelists, do you feel that jury service should be accessible to persons with indictable felony convictions, not under supervision, including, for example, murder, manslaughter, or sexual assault? Professor?
I mean, certainly, if you're excluding people from a core democratic institution, there should be evidence that they are incapable of doing the job or that their participation harms the process. And in the absence of that evidence, and there isn't any, in fact, in the face of contrary emerging evidence that people with felony convictions can make important contributions and enhance the public confidence in the verdicts, I would recommend dropping the ban. And we're seeing that more and more. Many states are at least dropping the length of the ban. So for example, Connecticut just dropped the ban to 3 years following conviction. DC just dropped it to 1 year following conviction. So that's certainly a state trend that I would recommend.
Dr. Rose, thoughts?
Completely agree. I think we are long past needing to look at the felony restrictions and long past needing to really revisit why we're doing this and what pernicious effects it can have.
All right, thank you. One last question we have, if you just identify yourself, please.
Sure. Andrew Bruck, the Acting Attorney General.
Welcome.
Thank you. So I realize it's exceedingly dangerous to be the last question before lunch, so I apologize for that. But I have a question about jury records and demographic data, and that's in part because I'm on a panel tomorrow about jury records and demographic data. But I figured I would use the opportunity while we have two researchers here. What types, in a perfect world, if you had total control, what type of information would you want about jurors and the jury pool? And I guess sort of a second part to that question is, what jurisdictions are doing this best that we should be looking to when we think about having a robust data set?
Why don't we start with Professor?
Well, I think the best practice is to have data that matches census data, because that's what allows for the apples to apples comparison of who's in the community versus who's in the jury system. So asking questions in the same way will allow for more accurate comparisons. I have a list of states, and I can share this with you in advance of your panel, that collect race and ethnicity data. And one of the key things is that a number of jurisdictions collect the data, and more are now posting that data in the aggregate, of course, never including personal identifying information, so that the public as a whole and parties can see the extent to which the system reflects the community. So for example, New York State posts an annual report. You can just Google it and pull it up online and see the demographic composition of the pool. So that'd be another step that I would recommend. That'll give you.
Thanks, Dr. Rose.
I'm so excited that New Jersey is considering doing anything that I think even basic information, as Professor Chernoff is mentioning, is so helpful and so important in this basic question of who is serving. I put in my appendix some recommendations for how to ask these questions to make it simple and to match the way the law is structured currently, but to at the same time allow some flexibility. I'm not sure if you're asking what questions should be asked or who should get the data. On who should get the data, I feel like parties need to have access to the data in ways that protect your privacy. But it is important for parties, particularly, criminal defendants who might be appealing, maybe making motions on this issue, to have data. It's just unreasonable to ask them to go out and collect them themselves, which a lot of them are in the position of having to do. I, as a researcher, would love it if, states would share through an open records request, share data that I could analyze. That's, again, juror privacy is protected, but would allow me to look system-wide at things. So I hope that answers your question.
It does. Thanks.
All right, thank you. So we've run out of time. We're very fortunate to have had Professor Chernoff and Dr. Rose with us. Thank you very much. Appreciate it. Fascinating. And thank you. Thank you, everybody.